Joyce, if I have you, I'm going to bring you into the conversation because I know that you obviously had a reaction online. I saw your tweet earlier today talking about this appeal filed by the Department of Justice. Let me read that for folks. We try and get Hugo back too, so we'll want to bring him back into the conversation. DOJ has filed a motion to expedite its appeal on the remaining issues pending in front of the 11th Circuit after the Mar-a-Lago search. They cite the appropriate local rules for expediting and make a compelling case for it. Talk us through the case, if you will, Joyce.
Sure. So the reason that you expedite is when there's really no pending factual matters that have to be developed in the lower court before it's ready for the Court of Appeals to rule. And that's this situation. The parties have briefed the facts. They've talked about the law in their papers before Judge Cannon. And the 11th Circuit has already had a first bite at the apple when they ruled on the stay motion. The issue here is twofold. It's whether Judge Cannon should have exercised jurisdiction and heard this case in the first place. DOJ says no, she shouldn't have. The panel on the 11th Circuit that considered the stay motion agreed with DOJ, although they were careful to say it was just limited to that one early request for relief that they were viewing. But DOJ also says, and with greater weight, that Judge Cannon was wrong to slow down their criminal investigation, that she shouldn't have prevented them from using these documents, and that her order should be reversed in that regard, too.
Without a crystal ball, Joyce Vance, how do you expect the 11th Circuit to appeal, considering how they have to decide, I should say, considering how they have decided so far with some of their earlier rulings?
Well, in this circuit, frankly, Yasmin, it can be hard to predict because this panel of 3 judges, that's how the courts of appeals are configured. Instead of just 1 judge, now we have 3 judges. And in the 11th Circuit, these panels that consider preliminary motions, like the motion to stay, are not the same panel as the panel that hears the substantive appeal. So very likely that we'll have different judges. But DOJ's case here is a very compelling one. In fact, it's a straightforward sort of a legal case that hinges on the fact that once you're the former president, you don't have the right to retain these materials. You might have the right to look at them, right? I mean, Trump can certainly, like any other president, go to the archives and use his materials for research if he wants to, but he can't keep them at his hotel.
Neil, let me ask you about something that I said in the intro, which is that, that the Justice Department might be getting tired of what seems to be special treatment that Trump's lawyers are getting from the special master, and that is appealing the idea of a special master altogether. Can you just bring us up to speed as much as you know, like where things are in that process?
Yeah, so the Justice Department just on Friday filed a motion to say we want to appeal this whole question of a special master because, Jonathan, you don't get a special master if you're a normal person ever. Right. And Judge Cannon said the reason why he gets one is because he's the former president. That is not exactly powerful legal reasoning. And so the department has said, Court of Appeals, please hear our case right now. It's true that we can, do a lot of the criminal investigation on the 100 most sensitive documents, but there are thousands of other pages that we would like to look at, and you can't